propositions is absolutely crucial. So thanks very much to Nadia and Julian. And we've got another duo coming up, and these are the award-winning duo. Every time I see anything on Twitter or anything like that, it seems to mention Samantha Woodham and Harry Gates, both barristers at 4 Paper Buildings and co-founders of the divorce surgery. They're here to talk to us about the divorce surgery, but I'm quite interested in your new skills. So starting off with you, Harry, what's your skill that you've learnt during this time?
Well, I'm halfway through learning how to use a chainsaw,
Oh, wow.
which is dealing with my feelings of frustration at being cooped up inside.
Okay, and what about you, Sam?
Yeah, so 2 things. I've started doing cosmic yoga with my kids, which has been quite fun. And the other thing I've been trying to work out is how to make a quarantini.
Oh, yes.
Yeah, there's a lot of chat about it, but there's no recipes. But I've been trying to devise.
I had lots of cards. It's my birthday the other day, and I had loads of cards containing quarantine recipes, so I can send one to you. Yeah, right, it's your turn.
Right, well, I'm going to start off. Thank you, Suzanne, for that introduction. This very short talk is just going to recap a little for those who know and tell those who don't know what One Couple, One Lawyer is, which is the process that the divorce surgery operates. And then explain a little bit about how that differs from private FDRs. And then finally, what cases One Couple, One Lawyer is really suitable for and those that it isn't. So without further ado, what is One Couple, One Lawyer? In a sense, it's the Ronseal of legal processes. It really sort of, I can't really improve on those 4 words, One Couple, One Lawyer. In a nutshell, couples have the ability to have very early legal advice, and I do emphasize the very, with one impartial barrister that they choose together, who will never represent either of them going forward in the case, if indeed there is to be a case, once the advice has been given. Well, why do we do that? Well, I'm sure all the delegates to this seminar will need no persuading that all the statistics show that early settlement is vital for outcomes for children and for families generally. And in a sense, what we try to do with this process is to harmonise people's expectations right from the beginning. If they're sitting at the very earliest stage in a room, listening to advice from somebody who is an expert in their field, and I'm not talking about me particularly, and Sam will come on to explain about that in due course, and hearing the advice that they're both getting from that one barrister, then it really does have a difference. It's a very powerful process, actually, once you've seen it in action. So that's the plan. We're regulated by the BSB and fully insured by the BMIF. It was a fairly tortuous process becoming regulated. I appreciate it. It was a novelty for the BSB to be dealing with, and they certainly did very well with us, but it's quite a long process. In terms of what we ask of our clients, our process typically lasts 6 to 8 weeks, and it's for a fixed fee. It starts at £4,750 plus VAT. It slightly depends thereafter on the complexity of the case as to what the costs will be. But all the costs are fully quoted for before anyone commits to the process. Couples are screened individually at the beginning at what we call an introductory session for us to be able to ascertain whether there are any red flags as to why this wouldn't be suitable. For example, a looming jurisdiction fight, obviously a joint process isn't going to work for them, or serious allegations of relevant domestic violence and those sorts of things. But assuming that they pass that threshold, and indeed we pass their expectations, there then follows a disclosure process which we organise for them. And essentially we ask for all the information that is absolutely vital and none of the information that we don't consider vital. So for example, unless there are specific issues about the contents of bank statements, there does not follow backwards and forwards pages and pages and pages of bank statements in the process. In more complicated cases, we have a bespoke disclosure session which is a session which both parties join with the barrister who's going to be advising them in due course, and any questions, queries can be ironed out with the barrister, and further plans made to provide documents which are missing. And once all the disclosure is in and has been exchanged with each other, it's time for the advice. And the advice session usually lasts 2 or 3 hours, takes place exclusively remotely at present. And the barrister will essentially give a bracket as to what he or she thinks a court would do in the circumstances of their case based on the disclosure that has been exchanged. It is not a negotiation. It is essentially akin to an FDR indication. It's a very detailed one. And it's then followed up in writing. I don't think we quite commit to this, but about 2 days later. And that tends to be a 15, 20 page detailed written advice given on a privileged basis, which sets out all the advice that's been given. And that is essentially the end of our process. As I say, we don't negotiate. It's not a backwards and forwards in that respect. Of course, if people want to ask questions or don't understand part of the advice, then clarificatory questions can be asked, and again, responses provided on a privileged basis. But we do not try to finalise the case with them, as it were. Instead, we try to urge our customers to regard this as a tool, one of the many tools that they should be using in order to try to settle their case. And what we've found is that people like to take this advice, particularly into mediation, certainly round table meetings, or indeed negotiate directly around the kitchen table. A final option, which is certainly available to them, although we hope not too many people do this, is to rip our advice up into thousands of tiny little pieces and ignore it completely. That is absolutely their right. The only qualification to that is that couples can come back to us if they have a very, very clear and specific agreement that they want to be converted into a consent order. I'm thinking of the sort of mutual clean breaks type order, rather than anything that requires a sort of hidden element of negotiation. Again, if we found ourselves in that position, I think we wouldn't be able to assist. That rather breathless run through is all I was going to say about our processes and what we do. And so I'm going to hand over to Sam at this stage.
Okay, hi. So I was just going to go through how this differs from other types of ADR, in particular private FDRs, and also the sorts of cases that lend themselves best to it, really. So how does it differ from a private FDR? There are kind of a few main differentiators. The first is that the couples are taking the advice in the advice session without their legal teams. And we think that's a key differentiator, because it's really encouraging couples to take control, to engage and take ownership of the negotiation, which will then follow in terms of the concessions they're going to make or not going to make. But the counterbalance against that is that it isn't a process for negotiation. So neither of them are going to be making binding concessions in the room without talking it through with their legal advisors if they want to, and thinking about it quite carefully. The format of the actual advice session is very different from a private FDR. It's much more akin to a con, where the barrister kind of takes the lead and explains the background and the law and how it applies to the facts. The couples are engaged in asking questions, but there's no process by which each are giving submissions or anything like that. During the disclosure process, we get as much as we possibly can out of the couple on paper, so that the barrister has that in advance. So it's not a process where either of them are having to advocate for themselves in the room. And because they're there on their own, and because they're not negotiating in the room, that's why the written advice is so important, because it's crucially important that these two people can go away and know exactly what was said, and everything that's said in the room is reflected in the written advice. It's really detailed. And within the fee, we allow a round of questions. So if the couple go back to their solicitors and talk it through and they've got follow-up questions, they can come back to us and we'll make sure those are answered. It builds in, because they're not negotiating in the room on the day, builds in a period of reflection. And actually for some couples that can be really helpful. Sometimes the pressure of going to an FDR and having to settle on the day, if you don't then settle, feels like a failure. Having the ability to take the advice, think about it, read it, talk to your advisors about it, and then convene a roundtable meeting or go into mediation can be really helpful. And we find that the solicitors that work with us a lot tend to leave a week's delay between the advice coming out and a roundtable meeting, so that their clients can have a kind of think about it, let it settle in, have a chat with their solicitors and talk it through before they then enter into negotiations. The costs are lower than private FDRs, largely because you're not paying for representation on each side. But similar to a private FDR, we allow clients as much as we possibly can to choose the barrister that they want. So we're regulated in a way that we can use any barrister from across the family bar, provided they're up for it. So if there's a preference, then we can always reach out to people, and we always try and obviously get the right expertise for the right case. So that means, again, we're just super keen for clients to get the person that they believe in, so that when they hear the advice, they can really take it on board. In terms of particular cases that this works really well for, I mean, we're obviously most associated with very early stage advice. And we do love getting couples in very early on. But increasingly, we are getting couples who are midway through proceedings. And we're obviously seeing an impact of the cases being adjourned as well, that more and more couples are looking for different options and looking for remote options. And because we've been operating by Zoom for quite some time, we're set up for that. Cases which are most suitable, I mean, you know, obviously you've got one side who's not represented. This is a really good sort of situation for equality of arms, really, if you've got one side who doesn't have a solicitor acting for them. If there's already been a failed FDR, or there's just a general dissatisfaction with the court process, this idea of trying something different that's outside the sort of normal adversarial mode can be really attractive. Those who are particularly cost conscious. And in early stages, if you have a case that comes across your desk and it seems really obvious that it should settle through negotiation or mediation, but there are points of principle that they're stuck on, it can be a really useful way to get over those at the earliest stage, before they become entrenched. I think I'm probably gone slightly over time. I'm sorry, Suzanne. I think if the only other thing we were going to say is if you're interested, or if you have a case that you think might be suitable, Harry and I, because of the importance of the impartiality of the process, we kind of have a front of team staff who deal with client inquiries, because you don't want one of the couple to think that you've been nobbled by the other. But when it comes to solicitors or barristers, we're always here for a chat. So if you have a case that you think might be suitable, feel free to give either of us a call, and we can talk it through.
Brilliant, thanks very much. Really interesting to hear about it.